Your own.
All right, thank you, everybody. It's 12 o'clock, so the hearings are resumed now. Thank you. I just wanted to sort of move on now and shortly to the next set of questions under the other legal requirements and the matters, issues and questions that we've submitted. Before I do, does anybody else have any further comments on the duty to cooperate that they'd like to raise? Because that would be the opportune time to do it now. If not, then we will move on. Very good. So we shall now move on to the next series of questions, which is the next one being question 1.6, which deals with the matter of accordance with the Council's statement of community involvement and has the Council met its minimum consultation requirements under that. So perhaps I could ask the Council just to provide a brief response on that first, please.
It's Mr. Slater again.
Thank you, sir. Just getting the document on the screen here. So the document is CDO 116. It sets out what the Council's done. We're just finding that. Thank you. Yeah.
Just to say, while that's coming up on now, obviously we are aware of, we've read the statement of community involvement and obviously your submissions on that in terms of how you.
I mean, there isn't a great deal to add. We feel that that's the appropriate approach, that we feel it follows national guidance. I note that there are very few comments that have come, I think, from people making representations.
Okay, thank you.
We feel we've done it properly.
I think our answer is yes.
In that case, I just have one question on that then, if I can do that, please. Just reading through all the responses that we had and statements that have been submitted. I have had regard to the comments from, is it Elvington Parish Council? It is in relation to the development that's proposed there. However, there has been a recurring theme, it seems, from the respondents there about concerns of engagement, the council through the plan period, the plan production and preparation. It just struck me as being a bit, there was quite a lot of comments there that were saying the same thing. I just wondered if we could have a view from the council in terms of how that's been.
It is unusual because they're a specific consultee. They've been in correspondence with us by a letter and by email, so we're rather surprised about some of their comments about the approach that we've taken. I don't think there's anything else to explain that. We haven't, as far as I know, we haven't got anybody from
there isn't anybody, as far as I know, there isn't anybody
here today
to say,
to amplify what their concerns are.
I think just from reading their responses, it was a general concern about engagement at various stages. I think there was discussion about they'd held events or drop-in sessions based on plan, I think perhaps in the early stages, and that those were submitted to the council. But I think some of the comments were sort of responding to that the council hadn't engaged them about how those had been taking place.
Yeah, the references are in CD 13A about the details there, and we've engaged with them as we have with others. So it's odd that they should feel that there hasn't been engagement or appropriate consultation. Nobody else we've treated in the same way as them has made any comments. So, and they're not here to explain exactly what their problem is.
No, that's true. That's fine. I just had a query about that, really, in terms of what your response would be to that particular concern. But obviously they're not here to respond to that, but I'll take that on. Thank you. If there's nothing else, then we'll move on to question 1.7, which is relating to the sustainability appraisal. And we have touched on this already at some point through some of the comments that have been made. I'm just allowed to get seats changed over. The requirement of the sustainability appraisal is obviously, one of the requirements is to look at alternative options for plan making in various forms. So I was just really wanting to get the council's comments on how that has been undertaken through the sustainability appraisal in terms of looking at options. Specifically, I wondered, given the matters that we've talked about with York and Selby particularly, in terms of have options for housing, for example, sites within the HMA, have they been looked at through the sustainability appraisal as reasonable alternative options in the development of the plan for delivering housing needs? We have a change in the seats.
We've got Alison Cook, local plan project officer, and Pete Davis, who doesn't seem to have a... Oh, you do? Oh, you took it out earlier, right, of Wood Associates. So, yeah, Pete?
So I think over the course of the essay, from preferred option stage in 2013 through to the publication draft essay, I think a full spectrum of reasonable alternatives have been considered. So that includes consideration with regards to the spatial strategy and reasonable alternatives to it, housing growth and reasonable alternatives, employment growth and reasonable alternatives, strategic sites, and housing allocations. By the time that we come to the publication draft, 136 separate sites have been appraised. The outcome of that appraisal is presented in Appendix H, which is CD 009B. And there's an audit of the process in Appendix K that deals particularly with the strategic sites. So it takes the reader through the decisions taken by the authority from 2013 through to 2018, including reasons for sites being discounted, such as actually being built up, through to sites being subject to further scrutiny, rejected, and other sites being considered in detail in terms of boundary changes that lead to different quantums of growth being applied, be it housing or employment. Appendix I provides a detailed appraisal of all the strategic sites that are allocated in the publication draft. There was then an addendum to the publication draft essay that was produced in July this year, which is EXCYC 24's A to C, and that considers the further changes, particularly to housing requirements, but also the council's proposed modifications to the plan, and continues the story with regards to the changes in housing requirements, and updates the earlier appraisal, particularly in terms of that housing requirements consideration. So the relevant appendix then contains strikeouts and replacement text, as it is an addendum. As the essay is required to do, it sets out the reasons for selection of the alternatives, and then provides some considerable detail with regard to the reasons for rejection and ultimately the council's choice with regard to its preferred options. These are particularly sections 6.4 and 6.5 of the publication draft, updated, I think, by sections 5.3 of the addendum.
Okay, thank you for that run through there of the process involved. It goes back to my first initial, or one of my initial points really, in terms of the options that were looked at. Given that the council's position is that it is, or by agreement with the local authorities, it is to meet its own housing needs within its administrative boundary, within its own area. I go back to the question, is there are there reasonable alternatives to look at sites within the wider HMA in terms of, has that been looked at in terms of the council's approach going forward? Are there reasonable alternative sites to look at in terms of sustainability appraisal process? I've probably answered my own question there, I suppose. But I suppose what I'm trying to get at is, could you consider that to be a reasonable alternative approach to take for those sites, given the council's approach?
The essay with regard to sites responded to the call for sites. So the call for sites in 2014, update in 2016, and particularly at 2016, appraised all sites that went through the certain constraints tests.
I think this is more likely to be a matter of strategic spatial options.
Oh, okay.
Well, in simple terms, has the essay informed the council's decision to meet its own housing needs?
The essay was one of the pieces of appraisal and assessment and evidence that was used by the authority in making its decision. The deliberations are set out quite explicitly in terms of the publication draft essay, in terms of paragraphs 6.4.32, 6.4.33, and then 6.4.34 through to 36. The essay is only there to inform council's choice. This essay also then documents the reasons why, in this case, the authority chose a figure that was below that was considered marginally more sustainable.
Okay, if you bear with me just one moment, it might not look like it, but I am for the first time ever attempting to run a paper-light hearing. Though looking around me, I'm not sure I've been successful already. Which document were you referring to there, Mr. Davis?
So that's CD00, it should be 8.
008?
Yes. So paragraphs 6.4.30 through 32 through to 6.4.36.
Page numbers in a blue triangle at the top of the page. It's about 110 and following.
109.
Okay, perhaps just while we're finding those paragraphs, you can talk us a little bit through what options are being considered there.
So this picks up the story at the point where there were 3 different housing figures considered. So one was 867, based on MHCLG's figures in terms of the 2016 published information that used the 2014 population projections. There was then a 10% uplift, which was 953.
Well, okay, but the question there wasn't about the housing numbers per se. The question wasn't purely, well, it wasn't about the actual housing numbers, but it was about York's decision to accommodate its own needs.
Alison Cook, Local Plan Project Officer. It comes back to the points made in the Duty to Cooperate section, and in the sense that when we were discussing with, as part of the wider discussions with neighbouring authorities about how to accommodate growth within York, it was decided that York would be meeting its own need within its authority boundary.
Yeah, I know that, but what I'm getting at is whether that was a decision informed by the sustainability appraisal process or not. It was just a political decision taken by the council.
It wasn't an option, as I'm aware, that we looked at, given that it didn't seem reasonable, given that we didn't have the authority from the neighbouring authorities to consider land in their adjacent authorities.
Just so I'm clear then, it's not a spatial alternative considered in the sustainability appraisal?
That's correct.
Thank you.
Okay, thank you very much for that. I'm just going to see if there's other parties that want to speak. Mr. Dennis.
Thank you. The planning system has, since its inception in 1947, obviously the NPPF 56, stuck to the principle of balancing competing interests, and in modern thinking, that's integrating the principles of sustainability with development. That's paragraph 10 to 12, the NPPF, i.e. the demands of the economy, those of social needs, protecting the environment and prudent use of resources. The guidance outlined in paragraph 6 to 16, achieving sustainable design, section 10, meeting the challenge of climate change, and section 13, sustainable use of materials, section 7, the requirement for good design. In other words, the value of social return should be given equal consideration to, as well as economic turn and the long-term impact of a proposal on the public sector should be taken into account to ensure that inappropriate development is avoided. However, the NPPF also states that clear policies that will guide how these principles will be applied locally. However, the plan does not appear to have a strategy or mechanism in place to deliver a viability assessment for sustainable developments. If we just come down to the example of how it's done today, in the NPPF, I'm sorry, I haven't got the paragraph for this, just the quote, developers' schemes should not be subject to such a scale of obligations and policy burdens that their ability to be developed viably is threatened. However, this crucial wording is currently used by developers to appeal planning obligations if they prove they hinder the commercial viability of their schemes using a financial viability assessment. A good example of that was Wakefield Council required 30% affordable housing on a site at Pontefract General Infirmary. Viability assessment later, this cut this down to 5%. That's 6 out of 124 homes. The point is, obviously there's an apparent contradiction there in the NPPF itself, and people are probably using that loophole. The thing with the local plan in terms of its strategy, I fail to see how that loophole and anomaly and that defaulting to just an economic basis in terms of assessment is done, and that brings into question how the council proposes to put a suitable viability in alignment with the raison d'etre of the MPPF.
Mr. Wright.
So the spatial strategies that are reviewed in the sustainability appraisals do not include a set of reasonable alternatives with regard to the fixing of the boundaries for the Greenbelt. The boundary selected in the plan is the boundary that was established in the 1990 York Greenbelt Local Plan, which was not an evidence-based plan and did not have regard to the 8-mile radius. So a reasonable alternative for the outer boundary will be to look at an 8-mile radius boundary. 6 miles, sorry. It was 8 and it came down to 6. That hasn't been done. With regard to the inner boundary, the RSS diagram indicates very clearly the urban form of York within the inner circle. And so there is an alternative spatial policy strategy to consider with regard to the inner boundary. That hasn't been looked at by the council. It hasn't been assessed in any sustainability appraisal as a reasonable alternative. Making the strays green wedges and covered by green wedge policy would be a better policy to protect them. That as an alternative has not been considered in any sustainability appraisal. The fact that the council adopt a view that the Greenbelt should prevent coalescence with neighbouring settlements, when that policy existed previously from 1980 to 2008 and was removed by the Secretary of State when the Secretary of State created the policy in 2008 and subsequently in 2013. Regardless of that, they haven't considered the alternative spatial strategy of building towards the neighbouring settlements, which would fulfil the historic pattern of development in York. And all of those reasonable spatial alternative policies should have been not only considered in sustainability appraisals, but should have been the subject of discussions in a duty to cooperate.
Thank you, Mr. Wright. I'll allow the council to come back on that in just a second. Sorry, I can't.
It's Chris Atkinson from Barton Wilmore on behalf of Barrett and David Wilson Holmes. Clearly there's been various iterations of the sustainability appraisal over a number of years, and it's on the face of it, it's quite a detailed piece of work. I'd just like to make one point on it though, if we may. Our client's got a number of land interests in the city. There's two in particular, which is New Lane Huntington, which is ST11, and Manheath Cotmanthorpe, which is ST12. Now, both these sites were originally allocated in previous versions of the plan and had been found.
Can I just be clear? We're not going to be talking about those sites for too long, are we?
No.
That's good.
Yeah, so obviously, but they had positive scoring through the sustainability appraisal. And when the council reduced their housing target, numerous sites were removed as allocations, which include these two sites. We're unable to find any evidence, I think, within the SA which demonstrates that the current package of sites that have been put forward as allocations represents the most sustainable option. For example, there might be a reasonable alternative whereby some of the local site allocations could have been removed and some of the strategic sites could have been retained. So we're not aware of anything which demonstrates that as a potential option.
Okay, Mr. Atkinson, thank you. And thank you for not delving too deeply into your sites there.
Mary Cook, on behalf of the Langwith Development Partnership. We're concerned about the question of reasonable alternatives to ST15. And the detail is not for now, but just to flag up that we say Langwith, which is in the general vicinity but has different borders than ST15, is a reasonable alternative which has not been assessed. Point number one. Point number two, we're concerned that the SA, particularly in the case of ST15, has just looked at the site and has not looked at, in the context of the SA, infrastructure, in particular transport. On the map, all that is shown is an indicative route to the A64, and we can't see when they were SAing ST15 what exactly they were taking into account in the context of transport considerations. So there's a link there between progress that may or may not have been made with Highways England. I haven't seen yesterday's statement of common ground. It's not on the website yet. But I just want to flag up that it looks as if they've essayed sites, but not, at least in my case, the means by which you get to those sites in terms of infrastructure.
Okay, thank you very much. Perhaps turn back to the council and just to pick up on those points that have just been made, please.
Yeah, I'm going to pass over to Alison in a moment, but can I just make the general point that there's a fundamental error being run by a number of parties on this issue. Reasonable alternatives, there is a duty to assess what in the council's planning judgment is a reasonable alternative. There is not a duty to assess every single alternative to every single proposal, and the courts have made that consistently clear. You've got, with respect to Langwith, disguised attempts to bring in an emission site. Those points are not necessarily within the broad scope of the reasonable alternatives. You have the documentation which looks and sets out what reasonable alternatives have been considered. It complies with what is required by the law in terms of giving you the reasons for choosing the preferred options and the reasons for rejecting those alternatives which were considered to be reasonable. You've also got, you've got that both in the form of the essay itself and in the preferred options sustainability document in 2013, which shows you how matters were then progressed to the submission draft. So there's a fundamental confusion about what the duty is. This is not a disguised way of bringing in your site-specific concerns, and with respect, there's a touch of that. We say, if you look at the legal duty and the guidance, you look at the SA and you see, for example, green infrastructure, including green belt issues, is considered. And I'm going to ask in a moment just for that to be given chapter and verse. But you'll see at section 4.7 of the SA, the green infrastructure issues are considered. So far as the specific issue about the 6 miles and coalescence are concerned, well, 6 miles is only an approximation. The RSS did not seek, as I said in opening, to be prescriptive, and so there's a judgment issue there. And as for coalescence, of course, it's part of national policy. So I'm not sure where any of those points go. However, can I just hand over to either... You're going to deal with it. Right, sorry, Alison. Mike.
If I start with Mr. Dennis in terms of the views that are expressed and the failure for viability assessment within the plan.
I'm proposing to address that on the basis that it's not an issue of reasonable alternatives, but is a matter which will be addressed in phase 2. Can I leave it at that? Or do you want an answer now?